Hello and welcome to today's event. My name is Brandon and I'll be in the background answering any WebEx technical questions. Just a few housekeeping items before we get started. If you experience any technical difficulties joining the WebEx session, please dial 1-866-779-3239 or you can message the WebEx producer using the Q&A panel. During the presentation, all participants will remain in listen-only mode, and as a reminder, this event is being recorded for rebroadcast. I'd now like to hand this over to your speaker for today, Michael Borella. Michael, you have the floor.
Thanks, Brandon, and welcome everyone to this month's MBHB webinar on new ways of understanding patent eligibility of software and business methods. And before we get started, let's just take care of a little bit more housekeeping. Please note that all registrants for today's webinar will receive an email from MBHB within 24 to 48 hours containing a PDF copy of the PowerPoint that I'll be presenting here, along with the link to archived audio of today's presentation. For those of you who are seeking CLE credit for the presentation, please note that there are two randomly placed PowerPoint slides within this deck, inviting participants to complete a simple online poll question. You must complete both poll questions in order to confirm your active participation and thus be eligible to receive the CLE credit. We encourage you to submit any questions you may have during the webinar presentation using the WebEx online question submission module. Time permitting, we will attempt to address the submitted questions at the end of the webinar. If time does not permit, we will respond offline after the webinar. Thank you. All right, so let's go ahead and get started and take a look at the roadmap for today. So we're going to start off with a brief introduction to Section 101 and the two-part Alice test, just to get everyone up to speed on where we're going here. Then we're going to talk about what happened in the USPTO during 2020 with respect to Section 101, then move on to a similar update for the case law. But the meat of the presentation is going to be in that fourth bullet point, eligibility in practice, the three-factor test. And this is where I think things are going to get really interesting, because I'm going to be proposing that there's a very different way to view patent eligibility that, in my opinion, is more useful and helpful to practitioners and patentees than a strict adherence to the two-part Alice test. And then we'll finish up with putting this all together into practice, a few additional practice notes, some further housekeeping, and then we'll be done. It'll take about 75 minutes. All right, so let's go ahead and get started on the Section 101 background. Now, I know that of the approximately 500 or so of us that are in this webinar right now, many are patent attorneys who are very experienced and they know all about Section 101, and that's great. But there are a number of other folks here who are joining in who are more general practice attorneys, or they are executives at companies, non-attorneys, inventors, and so on, who might want a little bit more of a background to get us warmed up. So that's what we're going to do. This will go quick, and then we'll get everyone on the same page. So the most important thing to remember about Section 101 is it's the part of the patent statute, the part of patent law that tells you what you can get a patent on. So that is very, very important. And the statute itself is very short. It's very simple. You can have patents on articles of manufacture, machines, compositions of matter, and processes. Those first three things, the articles of manufacture, the machines, compositions of matter, are all tangible, physical items that you can, for the most part, touch or see or view in some fashion. Processes, on the other hand, are more ephemeral. Those are a series of steps that a machine or a person or some combination of machine and person might carry out to achieve a certain goal. So you might think, well, it's hard to think of anything that doesn't fall into one of these four categories, so virtually everything should be patentable, and that's true, except that the Supreme Court came along and said not so fast. Even though the statute itself indicates that there are these four very, very broad categories of patentable subject matter, there are certain things we just don't want you having a patent on, and those are the judicial exceptions, and there are three of them: laws of nature, natural phenomena, and abstract ideas. And rather than trying to describe what they are in general, let me just give you a couple of brief examples that I think will be illustrative. So let's say under laws of nature, let's say that I discover that a certain plant has healing properties. According to the Supreme Court, I cannot get a patent on using that plant for healing, for any purpose of healing. Like natural phenomenon, if I'm the first person to realize that moving electrons curve in a magnetic field, I cannot patent that phenomenon itself. And likewise, for abstract ideas, if I'm the first person to come up with the concept of wireless digital transmission, I can't get a patent on all uses of wireless digital transmission. So the notion here is that the Supreme Court thinks that these three exceptions are just areas of science and technology that are so fundamental that they need to remain in the public domain. So what can I get a patent on? Well, it's some use, some practical application, some narrower version of a use of these exceptions. So if I can use that plant to cure a particular disease, if I can curve those electrons to build some sort of power generation system, if I can digitally transmit wireless information to enable cell phone service, those ideas might be patentable, whereas the core exceptions are not. Now, our focus here is going to be on the abstract ideas exception because most of the case law is actually focused on that exception. Having said that, we are going to talk a little bit about laws of nature here because one of the major cases from last year is a law of nature exception case, but I'm going to contend, and I'll probably repeat this a couple times throughout the presentation, that in that particular application of the judicial exception law of nature, it was applied in a very similar way as the courts apply the abstract idea exception. So I see this as really just part of one big puzzle and not really three discrete and separable exceptions, if you will. Okay, so I mentioned that if you have a claim, it needs to be, or a claim of an invention that you want to patent, it needs to be statutory, it needs to conform to the four main statutory categories. And then if it also falls into one of the three exceptions, you need to claim your invention narrowly enough or specifically enough so that it doesn't encompass that exception as a whole. And it doesn't prevent others from using some fundamental law of nature, natural phenomenon, or abstract idea. Putting this all together, the Supreme Court came down in 2012 and 2014 with two cases that gave us what we call the two-part Alice test or the three-part patent eligibility test, depending on how you refer to it. I'm probably going to refer to this test interchangeably as a three-part test or a two-part test. It's shown here in this flowchart as a three-part test because it includes a statutory test, but some people just call it the two-part test and they ignore the statute. And to make things even more complicated, the USPTO, the Patent Office, has a four-part version of this test, which we're only going to touch on briefly because it hasn't changed much over the last year. So what did the Supreme Court say in Mayo and Alice? They said that the test works something like this. I'll walk through the flow chart, which, by the way, I took from the Patent Office's website because I think it's a pretty good representation of how the test is supposed to work in practice. You start off with your claim. You enter the flow chart. You go to step one. Is it statutory? Is it a process machine, article of manufacture, composition of matter? It almost certainly will be. There's very few things, as I mentioned, that fall outside of those four categories. If you happen to be claiming something outside of those four categories, like a data structure, your claim is not patentable subject matter. Can't get a patent on that. But in most cases, this is not an issue. So your claim is statutory, let's say. Then you move on to step 2A. Is the claim directed to a law of nature, natural phenomenon, or abstract idea? If the answer is no, and it's not directed to one of those judicial exceptions, you have patentable subject matter. Now, that doesn't mean you're going to get a patent. You still have to have novelty, non-obviousness, proper specification, and so on. But that's good news. You're not going to have a 101 issue. But if your claim is directed to one of those judicial exceptions, then you have to look further at the claim and figure out, does it have additional elements that recite significantly more than the judicial exception? If the answer is no, you don't have patentable subject matter. If the answer is yes, you do. This is the flowchart currently for Section 101, combining the statute and the case law. Now, you may be thinking, well, isn't this a little vague? I mean, what does it mean for a claim to be directed to a law of nature? I mean, how directed to a law of nature does that claim have to be? How related to the law of nature does the claim have to be? And likewise, what exactly is significantly more than a judicial exception? Is it a little more? Is it a lot more? It sounds like it should be a lot more, but how much is a lot? Those questions are part of the crux of the issue with Section 101 right now. We don't have answers to them. The Supreme Court didn't tell us. They just gave us the test and they told us to go figure it out. And that's fallen on mostly the Federal Circuit, which is the intermediate appeals court between district courts and the Supreme Court, which has exclusive appellate jurisdiction over patent law. And the Federal Circuit, to be blunt, hasn't done a great job in giving us a clear set or line of cases describing what the law is supposed to be. This is why patent eligibility remains such a major issue for so many people and so many companies, in that we just don't know what's patentable right now, especially in the areas of software and business methods. And I'll give a bit of a shout out to the life sciences people. Certain diagnostic methods of treatment run into issues not unlike this, but really we see this all the time in software and business methods, where this test can be applied in such a subjective fashion that it's very hard to tell ahead of time whether your claim or your invention is patentable or not. Okay, so let's move on from there. That's the basics on Section 101 and the interpretive case law. Let's talk about what happened in the USPTO last year in 2020. And in short, not much. Ever since the Alice case came down in 2014, there's been a lot of activity in the Patent Office interpreting this case and explaining to patent examiners how to examine patents in view of Alice and how to apply the 101 test. And it's been an evolving framework. It's changed as more and more Federal Circuit cases have come along. And finally, in 2019, the Patent Office said, you know what, as the executive branch of government, we have the right to interpret the Supreme Court law in a way that we think is reasonable. And so they published in early 2019 the revised patent subject matter eligibility guidance, or the PEG. And this was a fairly major departure from how the Patent Office had been examining cases before. And it essentially it advised examiners to apply what I would consider to be a more patent-friendly version of the Alice test than what the courts are applying. So in particular, this allowed for 3 discrete groupings of abstract ideas: mathematics, methods of organizing human activity, and mental processes. And then I mentioned earlier that there is this 4th step in the test that I didn't show in the previous flow chart. And the 4th step was to consider whether there's any additional elements that integrate the abstract idea into a practical application. And practical applications of abstract ideas might be improving the operation of a computer or other technology, making it faster, better, and so on. All right, so the PEG, the 2019 guidance, is very much focused on the abstract idea exception. It did have a few things to say about the other exceptions, but I'd say better than 90% of the meat is about the abstract idea exception, again, because that's where there's the most confusion. And ultimately, I still think this is a fairly ad hoc test. It is not consistently applied by examiners. It's more patent friendly, though, which is good if you're a patentee, except that if you want to enforce your patents and you think you might litigate later in court, the courts are still going to apply the more stringent Alice test that's not as patent friendly. So that's a pretty significant issue. But there's been no further eligibility examples, no further eligibility guidance since late 2019, when the PEG was slightly updated. So in June of 2020, last year, the Office integrated this guidance into the June version of the MPEP, the Manual of Patent Examination Procedure. And so now that is right into the Patent Office regulations themselves. So having said that, it's been a quiet year in the PTO, but it's not to say that the office has been completely silent on Section 101. They did publish a self-study on post-Alice patent examination, and you can go get it at the URL that's given here. And the office, what it did is it identified a number of what they call Alice-impacted technology areas. So these are areas, art units within the Patent Office, technology centers, that more often than not are going to be handling software inventions and business methods and diagnostic methods and methods of treatment and so on. And the office collected data on two metrics to evaluate how hard it is to get a patent through the Patent Office with respect to Section 101. And that is percentage of first Action 101 rejections, and then also 101 examination uncertainty, which is really just you take the first metric and you divide by all office actions. And so the observations that the office published in this document is that the 2018 Berkheimer case, which was a Federal Circuit decision that made the Alice test or interpreted the Alice test in a somewhat more patent-friendly way, reduced first Action 101 rejections from 35 to 28%, and the uncertainty metric dropped in a similar fashion. But it was really the 2019 guidance that we just talked about that reduced the first Action 101 rejections down all the way to 18%, and uncertainty dropped almost by half. So here the Patent Office is saying, look, it was a lot harder to get a patent through the 101 eye of the needle, so to speak. In 2018, it's gotten a little easier later that year, and then in 2019, it got easier again. So according to the office, they're in a position now where they're allowing more patents over 101 rejections, or you're just not getting as many 101 rejections in your applications. And in my practice, that certainly seems to be the case. But again, I got to bring up that really significant caveat, and that is because the guidance in 2019 is a more patent-friendly version of the Alice test than what the courts apply. So we are in this very real, risky, bizarre situation where you can have a patent application fly through the USPTO with no 101 issues to speak of, and then you get in court and it immediately gets shot down on the pleadings under Section 101. All right, now having said that, there was one other publication that was interesting from a 101 perspective, and that is the office published a white paper on its collected public views on artificial intelligence and IP policy. So this covers all of IP. It's not just patents, it also covers trademarks and copyrights and so on. And it involves the office asking major stakeholders in the IP community about the impact of AI, which is a very quickly growing and technology that's becoming dominant in a number of fields. What's the impact of AI on IP? Do things need to change? Are things okay the way that they are? And so on. And so it covers a lot more than eligibility, but from an eligibility point of view, from a 101 point of view, it represents a few points of view that came out of the stakeholders. Some stakeholders believe that AI-based inventions are really almost all abstract ideas because underlying AI systems is a lot of abstract math. There's calculus, there's linear algebra, there's a lot of stats, and it could be characterized as a method of organizing human activity, mental process, or mathematical concepts. So it would fall into those categories that the Patent Office find, and for the most part the courts find to be abstract ideas. Another point of view is that AI-based inventions, they provide technical improvements that are significantly more than abstract ideas because they involve these many of them involve these very large, massive models that in practice could only be developed and executed by a computer. If you tried to do it by hand or by pencil and paper calculation, it would take you billions of years. But the office said that in light of that, they really didn't see any reason to change how they examine patent applications that are directed to AI-based inventions, the patent eligibility of these inventions, I should say. And that's because the courts and the office so far has taken a case-by-case approach. They don't want to draw a line and say, if you're on this side of the line, your invention is eligible, and if you're on that side of the line, your invention is not. It's very rare that that would happen. And for AI, since there's just an infinite number of ways to claim an AI invention, and there's many different types of AI inventions, there was no reason to draw this line in the sand. And instead, the Patent Office is going to continue examining AI applications on their own merits, and that examination is going to be spread throughout a number of different art units. not all going to be going to a specialized AI art unit like you see in the Japan Patent Office or the Korean Patent Office. So that's the gist of this policy document with respect to patent eligibility in 101. Okay, having said that, let's move on and talk about case law update. And when I mention case law in this context, it's really Federal Circuit case law, because that's where all the action happens in Section 101, unless there's a Supreme Court case. And we know that there hasn't been a Supreme Court case on 101 since Alice. That may change soon, maybe, perhaps. But for now, let's focus on the Federal Circuit. So I've got a list of cases that were all 101 decisions coming out of the Federal Circuit last year. And this goes on for a couple of pages. But the way to interpret this chart is that on the left, you've got the name of the case, the next column going right, the judicial exception that the court either found in the claims, or if there was no judicial exception, then it's indicated as such. And then if there was a judicial exception, did the court also find that there was significantly more? And finally, was or were the claims found to be eligible? And anything in red is a case where at least one claim was found to be eligible, or the case was remanded back down to district court for proceedings. In every other case that's marked in black, the claims are found to be not eligible. So like I said, this goes on for a while. In terms of numbers, this was a very, very busy year for 101 in the Federal Circuit. There were a total of 38 cases, and I believe this to be the highest number of cases we've ever seen post-Alice on 101 in that court. Of these, 20 were non-precedential and 18 were precedential, which seems to indicate that a lot of these cases the court believed, or the panel that viewed the case believed, that they didn't really have to create any new law. They didn't have to create any new rules, and their holdings were really not that exciting. So that seems to indicate that the Federal Circuit, at least in some situations, seems to see that its 101 jurisprudence is solidifying. Now, there's some major exceptions to that, but at least there are certain types of inventions, and a lot of these are business methods where the court is just shooting them down left and right, and they're finding those methods non-patentable. Of all of the decisions, 26 were found claims ineligible, 9 found claims eligible, and 3 were split or remanded. That rate of about 1/4 of all cases in the Federal Circuit, claims being found eligible under 101, has been holding steady for the last few years. So not that much different in terms of eligibility rate, just more cases last year. Now, I mentioned that there's a big exception, and that big exception is American Axle. I am not going to go into a ton of detail about this case. I'm just going to refer back to it from time to time, just because it's an important case for a number of reasons. I spoke about this case in last month's webinar when we did our top 10 stories of 2020. I went into a fair amount of detail about that. So I'm not going to reiterate everything, but I just want to introduce this case as being perhaps the most interesting 101 case that's come out of the Federal Circuit, not just in 2020, but for a while. Now, to be fair, American Axle is actually a 2019 case. It was decided in a panel decision published in 2019. American Axle, the patentee, which lost and its claims were found to be ineligible, requested rehearing of the panel decision, and it also requested rehearing en banc. Rehearing of the panel decision was accepted or granted, and the panel actually came out with a revised decision, and they changed its mind on one of American Axle's claims, not claim 22, which is shown here, but one of the other ones. It said, okay, that claim might be eligible, but then it kept the holding of ineligibility for claim 22. And the court en banc split 6-6 in deciding whether or not to hear the case en banc. And so when you have a split 6-6, a tie en banc rehearing decision, then the panel decision holds. And so that means that the panel decision, as of right now, is good law, and the court is not going to hear this case en banc. But the interesting thing is that in the en banc decision, there were a number of concurrences and dissents. There were 5 different opinions, And the judges on the Federal Circuit are very, very clearly split on this one, perhaps in a somewhat hopeless fashion. But in any event, that's the background. American Axle is about manufacturing drive shaft assemblies, and just looking at claim 22 on the left here, there's three main elements to this claim: providing a hollow shaft member, tuning a mass and stiffness of a liner, and then inserting the liner into the shaft. And you do it in such a way, you do the tuning in such a way that there's two types of vibrations that the liner is going to damp. So if your drive shaft is in a car or truck, you get slightly less vibration and you get a smoother ride, less wear and tear on the mechanical parts of the vehicle. This claim was found to be ineligible. Now, the panel majority's reasoning for this was something that we're just going to keep coming back to over and over again, because in some ways it was truly bizarre. First of all, the panel majority looked at this claim and they applied what they claimed to be the two-part Alice test. And they said, this claim is directed to a law of nature. In particular, it's directed to Hooke's law relating frequency to mass and stiffness. Now, you may remember Hooke's law from high school physics. It has to do with the operation of a spring. It's a fairly simple equation. But where is Hooke's law in claim 22? It is not there. It's not recited by claim 22. As far as I know, it's not even in the specification, but the court said that it's implicitly required in the claim, therefore the claims are directed to a law of nature. Let's hold that thought for a second. The other reason that the court, the majority, did not like this claim is that the style of the claim was outcome-oriented. In other words, claim 22 recites a result without any particular pathway of getting to that result, no particular way of tuning these liners such that they damp two different modes of vibrations. And so for these reasons, the majority believed that it failed the first part of the Alice test, and that it was directed to an abstract idea. And then, for the second part of the Alice test, which is the search for the inventive concept with significantly more, the court here, or again, I should say the majority here, was very conclusory, and they just said, well, we don't think there's anything in the claims that involves significantly more, so American Axle, sorry, you lose. But let's take a step back. Why is this such an interesting case from a 101 perspective? What I did here is I took the Alice test and put it on the left. This is a summarized version of the Alice test without all of the language. And that is part 1, is the claim directed to a judicial exception? And part 2, if so, does it recite significantly more? This is a very simplified version of the Alice test, I admit, but it's there for reference. Now let's take a look at the American Axle test. This, as far as I can tell from reading the American Axle panel opinion, this is what the actual test they applied is. Does the claim rely on a judicial exception? So it's not, is a claim directed to a judicial exception, but does the claim rely on a judicial exception, even if that judicial exception is unclaimed? If so, does it recite a particular means of practicing the invention? So here you can see that what the test that the panel actually applied is different in a fairly major way from the actual text of the Alice test. And I'm not the only one to think this. Judge Moore of the Federal Circuit wrote an absolutely scathing dissent where she criticized the majority for essentially doing this and for a number of other things as well that we don't even have time to get into. A number of other judges on the Federal Circuit who dissented from the denial of hearing en banc, 6 judges out of the 12, also had similar opinions about the panel majority and what they did here. So how significant is this, though, if we take a step back? Why do we care so much about whether the Federal Circuit is applying the exact language of the Alice test or just making up their own test that seems to be a different variation of it? Well, here's why. Take a look at the diagram here of Hooke's law. And again, this is high school physics. It's a very simple equation relating the amount of force that you have to apply in order to compress or expand a spring. Does this mean that any invention that uses a spring is now directed to a natural law and automatically is directed to a judicial exception under Part 1 of Alice? Or put another way, does any invention that relies on an underlying law of physics now directed to a natural law and is therefore more likely to be found ineligible? Since every single invention ever relies on laws of physics in one way or another, this is a very dangerous precedent for patent law. The Supreme Court in Alice told us, don't let the exceptions become so large that they swallow all of patent law, and yet that seems to be exactly what the panel majority did in American Axle. And this continues a trend of the Federal Circuit slowly expanding the exceptions to get bigger and bigger and bigger, and boxing out more and more inventions from being patentable. So it's no surprise whatsoever that American Axle in late last year filed for petition certiorari. In January and February so far, there's been a number of amicus briefs filed. I think the count is 5 so far. And if you want some extra credit, read the brief from the Chicago patent attorneys, because that's was written by myself and my colleagues. And we brought up a number of issues with the panel decision, including the fact that we believe if the panel decision were applied to certain fundamental inventions like the light bulb and the telephone, those inventions would also be ineligible. So therefore, we think that if the American Axle law stays, that virtually anything, any invention can be argued to fail the 101 test, which is a bit silly. The brief in opposition is due on March 31st. We don't know when we're going to have a certiorari decision, but if there ever was a case that the Supreme Court should take up on eligibility post-Alice, this is probably it. Here's some speculation on my part. If certiorari is indeed granted, and we don't know that it will be, the odds are never good. But if we do maybe we get a good Supreme Court opinion out of this that clears up what the court really wants out of Section 101 and clears up how to apply the Alice test in the proper fashion. That might not be a bad thing. Or we could get a bad Supreme Court opinion that further confuses everyone and either adopts the panel decision in American, the panel's reasoning in American Axle, or makes things even more complicated. If the Supreme Court opinion is that bad, it might finally motivate Congress to do what it has been threatening to do for a long time and revise Section 101. If you'll recall, Congress made a lot of noise in 2019 about doing that. So now we have the election over, the impeachment hearings are over. Congress actually has to do some work now, and revising Section 101 might not be a bad thing, because usually you can get bipartisan support for patent law pretty easily as compared to other more hot button topics. But anyway, that remains to be seen. So we're going to keep our eyes on the Supreme Court throughout 2021 and see what happens there. All right, so we are at our first WebEx tracking poll. So what I'd like you to do is, if you want CLE credit, please go to the WebEx poll, which should be popping up on the lower right corner of your screen if it looks anything like mine. And in the poll, not in the chat session, but in the poll, go ahead and type in the word abstract. You can type it in uppercase, you can type it in lowercase, you can type it in numbers that looks like the letters. As long as it's legible to us, we will give you CLE credit. And don't forget to hit submit, because if you don't hit submit, it doesn't get submitted, and then we don't receive it. And if we don't receive it, we can't give you CLE credit. So please hit submit as well. The poll is going to remain open for a few minutes, and I'm going to leave this slide up here just for a few more seconds, and then we will move on to the next topic. Okay, so please, if you haven't completed the poll and you want CLE credit, do that, hit submit, get that taken care of. But we need to move on, and now we're going to get into the real meat of the conversation, and that is patent eligibility in practice, what I am calling the three-factor test. Just to be clear, the three-factor test is not something directly from the case law. It is not the two-factor Alice test, or the two-part Alice test. It's a different test that I believe in practice works better for understanding whether an invention is going to be patentable and how to claim that invention in a way that is more likely to pass whatever 101 challenges the invention might have, or the patent application might have in the PTO, or the ultimate patent might have in courts. It's based on the following premise. I think that strict adherence to the two-part Alice test as a way of thinking about Section 101 has, it's confusing, first of all, just because it's such a vague test, and both parts are vague. Nobody knows what directed to means. Nobody can tell me what significantly more means. And the examples from the case law are just all over the map and inconsistent. But really, if you look at what the Federal Circuit has been saying about inventions that it has considered the patent eligibility of over the last 6.5 years, you will find that there are 3 things that they are actually looking for. They just don't, it's just not part of, those 3 things don't really pop up as part of the 2-part test. All right, so I'll get to those in a second. Like I mentioned before, this is focused mostly on the abstract idea exception, but I'm going to be referring back to American Axle because that's a natural law case. Again, it could have easily been an abstract idea exception case as well. But one of the problems that we have in the computing arts and business method arts is that this whole notion of an abstract idea just doesn't make a lot of sense. The way that the Supreme Court applied it, the way that the Federal Circuit is applying it, because literally the word abstract means idea. It's something that exists in thought, but not having a physical, concrete existence. Software, anybody who knows anything about software knows that it is a physical, concrete, tangible thing. It exists in zeros and ones that are sitting in memory on your computer, on your smartphone, on your tablet, in your car, everywhere. Software is tangible. If it wasn't tangible, we would not be having this webinar. So the notion that software is abstract, which is a notion that the Supreme Court and the Federal Circuit, and to a certain extent, people within the Patent Office, some people at least within the Patent Office, seem to believe is just false. The problem is that since the courts have allowed us to consider something that's tangible, like software, to be abstract or intangible, that is one of the reasons why the exceptions have started growing, because now other types of tangible inventions are also being found abstract, like car charging stations and garage door openers. And again, even though it's a natural law, American Axle's way of inserting a liner into a drive shaft is now considered abstract, even though it involves these 2 very discrete physical components. And that's the danger here, is that if you believe that software is abstract, even though it's tangible, anything can be abstract. So I believe that a more accurate way of thinking about Section 101 is not to focus so much on the definition of abstract, which is now this complete legal fiction. It doesn't make logical sense. And instead, if you want to know whether a claim is going to pass through the current interpretation of Section 101 and the statutory interpretation, the Alice test, and so on, is that you want to have at least one element that is specific, technical, and novel. Those are the 3 factors. Now, if you're an experienced patent attorney and you hear me saying this, you probably are going to want to excommunicate me from the patent bar, because you're going to say, wait a second, that's not what the court said. That's not in the 2-part test. That's not in the statute. What are you talking about? Specificity, technical character, and novelty. And in fact, you might argue that those things, like specificity, that's really the domain of Section 112 of the patent statute that covers written description and enablement. And novelty could be handled under Section 102 of the patent statute, which is about novelty, or maybe under 103, which is about non-obviousness. Yes, there is an overlap between Sections 101, 102, 103, and 112. I'm not the first one to notice this. That overlap has existed at least since Mayo, if not before. It's just become more and more prevalent. I will tell you more about that overlap in a little bit. I will tell you more about when to use this framework and when to use the Alice test in a little bit. But I really want you to pay attention to this, because I'm going to give you the case law that establishes these 3 factors, and I'm going to give you empirical data to back up the fact, in my opinion. I'll leave it as an opinion. In my opinion, that these 3 factors are more valuable to you as a patent attorney or as an inventor or an applicant than strict adherence to the 2-part Alice test. Okay, start with specificity. why do I think that Section 101 requires specificity? Well, I'll tell you why. The Federal Circuit has told us that it does over and over and over again. Many, many cases. One of the best examples is McCrow, which was from 2016. It's not a new case. It's been around for a few years. It's highly cited. It also uses the root word specific at least 15 times when referring to the claims, which were found to be eligible. In fact, the court over and over says, these claims are specific, they're claiming the invention in a specific fashion, and therefore, we find the claims to be eligible. McCrow is not the only case that does this. Enfish, one of the early trading technologies cases, SRI versus Cisco from 2019, are just 3 examples of many cases where the court uses the word specific to find claims to be patent eligible, or to describe claims that the court ultimately finds to be patent eligible. Now, on the converse, a lack of specificity in claim language can in fact cause the Federal Circuit to find those claims ineligible. And that was the case in the Chamberlain case, in Electric Power Group, in Two-Way Media, and a whole long list of additional cases. So what this tells me is that the Federal Circuit, when it applies the 101 test, is actually applying some form of a specificity test, even though that's not part of Alice at all. All right, so what exactly do I mean by specificity? Do I mean claim breadth? And I think specificity and breadth are cousins, but they're not exactly the same thing. Instead, specificity has to do more with how you write the claim and whether it's outcome-oriented or not. And outcome-oriented, we saw that in American Axle. Those claims were outcome-oriented. They claimed an outcome rather than a way of achieving that outcome, and that was one of the reasons the court didn't like those claims. So non-specific claims are outcome-oriented. They recite a result rather than steps taken to achieve the result. We have a lot of really good quotes from the case law about how much the Federal Circuit does not like these non-specific claims. In Electric Power Group, the court wrote that defining a desirable information result and not limiting your claims to an inventive means of achieving that result can render the claims ineligible. In American Axle, in one of the concurrences to the denial of rehearing en banc, Judge Chen wrote that a claim may be held ineligible if it invokes a natural law to achieve a desired result without reciting any further limitations to accomplish that result. So this result-based or outcome-oriented claiming, black box claiming is what I've heard some people refer to it as, is considered a bad way of claiming an invention. Instead, you want to claim the invention in such a fashion that if you need 5 steps to get from beginning to goal, you claim those 5 steps, or at least most of them. So how do you write claims to be specific? Well, there's 5 different types of specificities in claims that I can think of. Maybe there's more, but the 5 types are a specific function of a specific element that does something in a specific way to obtain a specific result and solve a specific problem. Think about those. You don't need all 5 of those in every single claim to be patent eligible, but the more you have, the less likely your claim is going to be outcome-oriented, and the less you have, the more likely your claim is going to be outcome-oriented and thus cause you all kinds of problems. Now, of course, if you're a traditional patent attorney, your head is exploding and saying, no, 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 this is the domain of 112. And as I've said before, and I'll say this again, the 101 test since Alice has really evolved to take on characteristics from Section 112 that would normally be part of the 112 test. And I can get into some detail offline maybe about why this is happening. It's almost more political than legal, but it's happening because the Federal Circuit is interpreting the word abstract to mean high level or vague, in addition to meaning things covering both things that are tangible and intangible. Anything that's high level or vague in the Federal Circuit's opinion could be found to be abstract. And that's really something that the vagueness or the degree of specificity in a claim has traditionally been considered under Section 112. And I'm not the only one to say this. Judge Moore from the Federal Circuit wrote in dissent in American Axle that the majority had been applying an enablement on steroids test in the guise of Section 101 to find claims ineligible. So whatever you do, don't argue with Judge Moore. She's usually right. Moving on to the second factor, technical character. All right, the notion that claims have to be technical is actually not something in U.S. patent law until recently. It hasn't really been there. Over the last 40 years, for the most part, we've been fairly open to the concept of business methods in U.S. patent law, whereas in certain other jurisdictions like Europe and India and Australia and to a certain extent Canada, business methods are very hard to get patents on. But in the US, up until Alice, they really weren't that hard to get patented. And even after Alice, you can still get some business methods patented. It's just a bit harder. But why do I think that Section 101 now requires this technical character? Well, I'm just going to stick with the language of the case law coming straight out of the Federal Circuit. In Trading Technologies versus IBG, the court there wrote that about the claims, they're focused on providing information in a way that helps the traders process the information more quickly, not on improving computers or technology. So we're making people perform better. We're not making computers perform better. In Versata, a claim akin to creating an organizational management chart fails to solve a technical problem using a technical solution. So again, we have this notion that you have to be dealing with technology. In Shortridge, generating certified payroll records is an abstract business practice. In Section 101 lingo, the word business is a synonym for non-technical, or it's an antonym for the word technical. So when you see a court talking about a claim being evaluated under Section 101 and talking about that claim or referring to that claim as improving a business practice or directed to a business practice, that's a bad sign for that claim because it's almost certainly going to be viewed as not having sufficient technical character. And in SAP, under the principles developed in Section 101, patent law does not protect an advance in mathematical techniques in finance, no matter how groundbreaking the advance. So again, finance, being a business practice, is non-technical. On the other hand, if your claims do have the appropriate technical character, the court is very likely, or at least more likely, to find those claims to be eligible under 101. So in Packet Intelligence, a relatively recent case out of the Federal Circuit, the court wrote that the claim solves a technological problem by identifying different packet flows than doing something useful with them. In SRI, a hierarchical network monitoring system was found to be rooted in computer technology to solve a specific problem. There's the word specific again, by the way. In KPN, the claims were directed to a non-abstract improvement in an existing technological process. And in Thales, here we had very broad claims that were found to be eligible because the underlying specification described the technical problem and the technical improvement involved in the invention. So, you know, I don't think there's really any debate that the more technical your claim language is, and the more technical the problem that you're solving is, the more likely those claims are going to pass muster under Section 101. If you don't have enough technical character, the claims are more likely to be found ineligible. If you have more technical character, you're going to do better. How to think about this? Again, I've mentioned that in US patent law, we don't really have this notion of requiring a technical character or requiring a technical solution to a technical problem. There was a little bit of that in the part of the regulations involving covered business method reviews, but it's really not a core part of the US patent law, at least not in the statute. So to help you think about this, I've got this chart, and I took this from a couple of European patent attorneys who I work with from time to time. And I think this is a great example of how to think about technical character, because this chart lays out the technical character of inventions on a spectrum. And on the left, you've got more technical inventions, and on the right, you've got less technical inventions. So on the left, you've got inventions directed to things like engine management, TV signals, error corrective coding, image noise reduction, right? Those are pretty clearly technical. Processor thread management, sure. On the right, on the other hand, you've got retail schemes, hedge fund risk analysis, derivative trading. Those are business problems, and those, as I mentioned before, are business problems are considered non-technical, even if you're going to use a computer to solve them. The problem itself is considered non-technical. In the middle, you've got inventions that could go either way, DNA sequencing, alignment, film animation, and so on. For the most part, if you claim these inventions right, you'll probably be able to overcome any 101 issues, but if you claim them in a rather vague way, or you don't emphasize the technical character, maybe not. So in a nutshell, what this spectrum tells you is that on the left, you're improving how machines work. On the right, you're improving how businesses work. And in the middle, you're improving how people work. And so there's this belief that has now been baked into the Federal Circuit case law that to meet the requirements of 101, you really want to be on closer to the left side of this spectrum and not so much on the right side of this spectrum. There are exceptions, but the exceptions are pretty rare. So let's talk about some examples from the USPTO. The Patent Trial and Appeal Board a couple of years ago published some informational decisions on Section 101. So these are not binding PTAB decisions, but they're informational decisions, so they're helpful in telling us what the PTAB is thinking about how Section 101 should be applied. And these cases, to a T, follow what I would call the European standard. If you have a technical solution to a technical problem, your claims are found eligible. And if not, they're probably going to be found ineligible. So let's walk through them. In Fouts, optimizing signal-to-noise ratio in a magnetic resonance tomograph. Eligible. That's a technical invention. Olson, transforming coordinate systems of catheter navigations to a different coordinate system. That's a technical problem. Eligible. Kimazuka, on the other hand, selecting a golf club. That is not solving a technical problem. That's solving a business or entertainment problem, I suppose. That was found to be ineligible. Savescu, software for creating a lifecycle workflow for a project. That was also found to be ineligible, although I would argue that one of the main reasons is that it was focused, the claim language, the claims were written in such a way that actually made it more likely to be found ineligible. There certainly are software lifecycle workflow type inventions that are clearly eligible. But in any event, that was found to be ineligible. In Smith, this was actually a really interesting case because it was found to be eligible even though it was related to solving a business problem, and that was a hybrid derivatives trading system. But here, the problem was scoped so that it was about synchronizing trades that are both made electronically and on a floor based on a timer. So you really did need a computer to solve that problem, and it turned out to be a technical enough problem. This was a split panel decision in the PTAB, so one judge didn't like it, but the other two did, and this is now an informational decision. So those claims were eligible. And finally, in Hanoun, a neural network speech recognition system was claimed in a technical enough manner that it was found to be eligible. So the PTAB seems to be applying the European standard, which is reflected in that chart of the spectrum of technical character that we just looked at, this chart right here. Okay, finally, our third factor. We have established so far that the Federal Circuit likes it when claims are specific. The Federal Circuit likes it when claims have a technical character. In the converse, the Federal Circuit doesn't like it when claims are not specific or don't have a technical character. What about novelty? This is probably the hardest of the three factors to get your head around just because it's fairly vacuous. We know that Berkheimer in 2018 introduced the notion of novelty into the prong 2 of the Alice test, in that if you're looking for an element that has an inventive concept or that's significantly more than any abstract idea or law of nature or what have you in the claim, you must consider whether the claim elements are well understood, routine, and conventional. So that consideration, whether claim elements are well understood, routine, or conventional, is almost certainly a factual consideration that requires comparing the claim elements to the prior art. Because if something is well understood, it's got to be in the prior art, otherwise it wouldn't be well understood. Right? That's almost like a synonym for known. So even though Berkheimer came down in 2018 and explicitly made a comparison between claims and the prior art part of the 101 analysis, it hasn't really been fleshed out much beyond that, but it also wasn't the first case to do that. In fact, I challenge anyone to go to your favorite legal database, Westlaw, Lexis, or Google, whatever you use, and type in a search phrase such as Federal Circuit Alice 101 prior art. and you will find a load of cases where the Federal Circuit, in making a 101 decision, explicitly compared the claim language to the prior art and used the words prior art when doing so. This is a list of 8 cases that I was very easily and quickly able to find where this explicit comparison exists. I could easily find twice as many more. The Federal Circuit has been doing this at least since 2015, so this is not new at all. The real challenge here is that the nature of the 101 prior art analysis, if you want to call it that, is really unclear. We know that it can impact both prongs of the Alice test, and here's where things get really tricky, because the Federal Circuit has said from time to time, at least certain panels have said, that you need to apply each prong or step of the Alice test as a whole. You view the claim as a whole and determine, is it directed to a judicial exception? You view the claim as a whole and decide, does it recite something more? But other panels have come and said, well, if you've got prior art elements in your claims, you can ignore them when carrying out the test under or the evaluation under step 1 or step 2. So this is where things get confusing, because you've got different panels saying different things. But the problem, or the issue at hand here, is that regardless of how you look at it, there is some aspect of novelty that has crept into the Section 101 test. In fact, in Mayo, Justice Breyer explicitly said that there is some overlap between 102 and 103, between novelty and Section 101, even though in Diamond versus Deere, back in 1980, the Supreme Court said there most certainly is not. So this conundrum remains. Okay, we now have our second tracking poll. So what I'd like you to do is, if you want CLE credit, open up the poll, go in there, not the Q&A session, not the chat session, but open up the WebEx poll, type the word abstract. You can use uppercase letters, lowercase letters, and hit enter, hit submit, because otherwise we're not going to get it. And we can't give you CLE credit if we don't get it. And we've got about 15 some odd minutes left, so we're going to wrap up, hopefully right on time. And we're going to finish up with a couple of really interesting things, a couple of diversions into other aspects of Section 101, but we're going to wrap up pretty quickly. Okay. Now, as an aside, because there's nowhere else that this really fits, I want to talk very briefly about a prosecution strategy. Let's keep, let's by all means keep in mind the 3 factors that we're talking about, of the 3 factors of patent eligibility: specificity, technical character, novelty. With that in mind, there's actually a really interesting trend that I'm seeing in the patent office, in my own practice at least, in that you can overcome 101 rejections in the PTO with a good inventor affidavit or declaration, if you have a good story. So let's say that you're prosecuting a patent and you've got an examiner, and you and the examiner just don't seem to be able to agree on Section 101. The examiner is rejecting the claim. The examiner doesn't want to withdraw that rejection. You think the claim should be eligible. You're kind of at a point where you can't really make any more reasonable amendments. What do you do? Well, if you have a good story with respect to the creation of that invention, you can have an inventor, or maybe someone at the applicant who has personal first-person hands-on knowledge of the conception and reduction of practice of the invention, write an affidavit about that. And this is where I think, I'm going to use the word story again. We human beings are storytelling people. Having a good story here can really make a difference. So here's what you can do if the facts of your case allow it. You have an affidavit where the inventor describes the technical problem that he or she was facing. Maybe there was a need in the relevant industry. Then how did the inventor go about solving the problem? What did they struggle with due to existing technologies being insufficient? How did they conceive of the invention? Did they have some eureka moment in the bathtub where they suddenly realized, oh, hey, this is going to work? Or was it more likely a slower progression towards a solution with some trial and error? And then describe the technical aspects of the solution, how and why it works. If you can, make analogies from these technical aspects of the solution to the case law. Now, you can't do that really in the affidavit because the affidavit should remain factual, but you make that in your attorney's arguments in an office action response or an appeal brief. Also, if you have good customer feedback, public response to the solution that the inventor came up with, talk about that. Did this invention lead to increased sales? Did it directly lead to positive customer feedback? And was there any copying by competitors? If you can check all these boxes, you've got a really good story. And even if you can't check all of them, if you can check most of them, you've probably got a pretty decent story that you can put in front of the examiner and say, look, this is the nature of the technical problem. This is the nature of the technical solution. And look at all of these great things that happen. Therefore, it is an improvement over the prior art. It's not conventional. It's not well understood, routine, or conventional, or anything like that. Now, if you think that this looks a lot like arguing secondary considerations of non-obviousness, you are right. But I have had this technique work in the patent office. So if you are at an impasse and you're not ready to take the case to the PTAB yet, this is not a bad idea. Give it a shot. See how it goes. In any event, let's continue on. What about the data that I promised? I promised back, I don't know, 20 some odd slides ago that I've got data to back up the fact that I think the 3 factors work better than the 2-part test. So we're going to go back to the 3 factors and finish off on this note. So last summer, one of our summer associates, Ashley Atzenbiller, and I scored 24 Federal Circuit cases for specificity, technical character, and novelty. And we scored these cases each on scales of 1 to 2 for each of these factors. So specificity got a score, a score of 0 to 2. So specificity got a score of 0 to 2. Technical character, a score of 0 to 2. Novelty, a score of 0 to 2. So the overall sum, if we were to add these together, would be 0 to 6 for each claim. How did we go about doing that? Well, if a claim was specific, it might get a 2. If a claim was not specific and instead it was outcome oriented, it might get a 0. If it's somewhere in between, it would get a 1. And we made these evaluations not on our own subjective view of the claim language, but we looked at what the Federal Circuit actually said in the case. And if they said this claim is very specific, then it's going to get a 2. If they said that this claim is a technical solution to a technical problem, technical character gets a 2. If they said that this claim is not a technical solution to a technical problem, then technical character gets a 0, so on and so forth. Of these 24 Federal Circuit cases, 12 were ultimately found eligible and 12 are not. So we've got 12 wins for the patentee and 12 losses for the patentee. The full results are at an article that we posted on the Patent Docs blog, and there's a brief overview of one of the charts that we used in that post on the right. But without going into a ton of detail about this, what I thought was really super interesting was that if you take those sums, those overall scores of 0 to 6 for each case, which again is based on the actual language of the Federal Circuit, and you correlate those sums with the eligibility outcome, which is binary, yes or no, the correlation was a 0.91. This is a massively huge correlation, much better than we thought it would be. And a perfect correlation is a 1.0. So this is actually not that far off from a perfect correlation. So that means that the more specificity, technical character, and novelty you have, the more likely your claims are to be eligible, and the converse applies too. The less of those 3 factors you have, the less likely your claims are going to be eligible. And I know that a correlation is not a causation. All right, that's crystal clear. But in this case, I would argue that it is, because we know what the Federal Circuit is saying. And if we look at these cases, the Federal Circuit is saying, because this claim is specific, it is eligible. Because this claim lacks novelty and is too close to the prior art, it is not eligible. We have that data. So I would argue that this correlation actually has a very strong causational relation, or it indicates a very strong causational relationship between the 3 factors and the outcome. And that means that if you write claims to have these 3 factors, you're much more likely to have a positive 101 experience than not. Now, some of the other correlations we have between the individual factors and the overall outcome are not as high. So you really want to have all 3 factors in your claims to get this really massive correlation of 0.91. And in particular, technical character is the most highly correlated, followed closely by novelty, and then specificity is the least correlated. And it's a little disappointing from a patent drafting person's point of view, because specificity is what you have the most control over when you write claims. But if you also have a fair amount of control over the technical character, because if you have an invention that has, perhaps using math to solve an engineering problem, focus on the engineering problem, don't focus just on the math, and that will give you some more technical character. Okay, we also, or actually also after Ashley went back to law school, and I had an opportunity to focus a follow-up study, which I did myself, on just graphical user interfaces. And the reason I did this is that I do a lot of work in the software space and graphical user interface space, and you would think that graphical user interfaces as being these really fundamental aspects of computing, they're essentially human machine communication through graphical elements, and they're so important to our everyday lives that this should be an area that's ripe for innovation. In particular, what is one of the #1 things that people complain about with software? It has a bad interface. Oh, there's a function I wanted to use, but I couldn't find it because it was buried 8 menus deep in the user interface. People notice when graphical user interfaces are bad, and they complain very loudly about them. So the challenge in providing good graphical user interfaces, in my view, is you want to maximize the user experience by providing that sought after information in a consistent, logical, and low effort fashion. And there's a lot of room for innovation here. I've personally written many, many patents directed to various aspects of graphical user interfaces and how to improve them and make them better and solve problems with them. So we took 8 Federal Circuit cases involving the patent eligibility of graphical user interfaces, and we ran them through the 3 factors. And here I simplified things a bit. Instead of scoring on a scale of 1 to 2 for each factor, I just scored in a binary yes or no, just to kind of keep things a little bit more straightforward. And what you'll see is that even within this very limited universe of graphical user interface Federal Circuit 101 decisions, there is still a very strong relationship between the 3 factors and the eligibility outcome. Just to give you an example, the SAP case was a method for calculating, analyzing, and displaying investment data. It was not specific, very broad outcome-oriented claims. It was not technical because it was about a business problem, investment data. Arguably, it was novel. The Federal Circuit admitted that, but the overall outcome was ineligible. On the other hand, we had the trading technologies case. Actually, this is the first of 3, but this particular trading technologies case had a very strong technical factor. It was also specific and novel. It was found to be eligible. The other trading technologies cases didn't go so well. Looking at a couple more, Core Wireless, a mobile user interface for limited size screens for very small mobile phone-based screens. It was specific, it was technical, it was novel, it was also eligible. I'll leave all of this for you to take a look at in your spare time, since we've only got a few minutes left. But the bottom line is that even if you apply the 3 factors as a way of evaluating just a subset of different types of software or business method inventions, it still seems to work pretty well. Okay, so if I were to sum all of this up, all of this talk about the 3 factors, I would tell you this in one sentence: a claim is not directed to an abstract idea, or really to a judicial exception, if it includes at least one element that it's a specific technical improvement not found in the prior art. Now again, experienced patent attorneys or conventional traditional patent attorneys are going to try to excommunicate me from the bar for saying that, because it just munges together notions from several different parts of the statute. But as we've seen, there's a really good reason to believe that this is true. We've got empirical evidence that shows that this is in fact the case. If you want to write a claim and not have to deal with too much 101 nonsense, it should be specific, technical, and novel. And there should be a nexus between the claim's specificity, technical character, and advance over the prior art. So you don't want to have one specific element that's not technical and is in the prior art, and you don't want to have then another element that's technical but not specific and in the prior art. You want to have one claim element that has all 3 of these characteristics, or at least several claim elements that are tightly coupled that have these 3 characteristics. Now, just to kind of drive a nail in the coffin of anyone who might complain about this, If you don't believe that this sentence in the first bullet point is in fact a good way of thinking about 101, let me read to you something from the Federal Circuit. And in fact, the Dropbox versus Syncrest Technologies case, which came out in May of last year, they wrote, the court wrote, an inventive concept exists. Oh, and this is, of course, was a 101 case. An inventive concept exists when a claim recites a specific, discrete implementation of an abstract idea where the particular arrangement of elements is a technical improvement over the prior art. I wrote this sentence first in an article I wrote this sentence in the first bullet point in an article that was published in March of 2020. This case came out in May of 2020 and essentially says the same thing. So I think we're onto something here. Okay, so how do you apply the three-factor framework? The last thing I want you doing is calling up a patent examiner or getting in front of the PTAB, or even worse, getting in front of a district court judge and saying, hey, let's not apply the two-part Alice test, let's apply the three factors. And that person is going to say, why? And you're going to say, well, some guy in a webinar told me to do it. No, please don't do that. You apply the three-factor framework for the most part before you file the application, preferably before you file the application, in discussions with your clients and determining claim scope, determining claim style, drafting of the specification, or when you're amending claims during prosecution. If you're dealing with a 101 rejection, think about the three factors. They can only help you. Also, if you have a granted patent and you're evaluating its enforceability post-grant, or maybe you want to enforce it, and you want to decide what's the risk of running into a 101 challenge, and is that challenge going to be successful? Or if you've got a patent that someone is threatening to assert against you and you want to try to kill it off under 101, that's when you can apply the three factors, and it'll give you a pretty good idea of the viability of those issued claims. But of course, when you are dealing with patent examiners, the PTAB, the courts, apply the Alice test, run through the two prongs of the Alice test, but keep the three factors in mind, because ultimately they're what matters. And we've seen that over and over and over again. The Federal Circuit has told us many times the three factors are really what counts. All right, so we're going to put it all together. What was 2020 all about? It was not an exciting year in patent eligibility aside from American Axle, and we're going to be paying attention to that case throughout this year to see if it gets picked up for review by the Supreme Court. The two-part Alice test remains unclear and inconsistently applied. It's very confusing to apply in practice. It doesn't make a lot of sense, but the three factors are what really describes what the Federal Circuit has been looking for, and in my view, it's a better way of thinking about Section 101. And we expect things to continue in 2021 along these lines until there's a grant of certiorari in American Axle, or if that happens or not happens, Congress may finally decide to review and revise Section 101. Okay, so my name is Mike Barella. I work at MBHB in Chicago, a patent law firm. This is my contact information. Don't hesitate to contact me. Drop me a line if you have any questions. I'm happy to respond. I've got a couple of speaking engagements coming up. There's a virtual webinar for AIPLA on May 6th. I'll be talking about where we are with patent eligibility. September 27th and 28th, there's a PLI conference in New York. This may be in person depending on how vaccine rollouts go, and the same for the October 18th and 19th PLA conference in San Francisco. If that happens to be an in-person conference and you come and I'm there, feel free to say hi. I write for the Patent Docs blog, which has much of what I've said about Section 101 today has been published by Patent Docs over the last year or so. So by all means, drop by there. We do a lot of coverage of recent case law as well as these overview articles. Speaking of which, these are some of the articles that you might want to read. If you like this presentation, these articles go into more detail, provide citations and so on, supporting what we've talked about here. You can connect with my firm, MBHB, on social media. You can follow us. And thank you very much for your time today. I really appreciate it. Have a great day.